Good morning, everyone. First of all, let me introduce myself. My name is Maria Dimitruk. I'm the president of the FBE New Technology Commission. And as one of the organizers, I had the pleasure to open the second day of the conference, Digitalizing Justice and Empowering Legal Excellence. Today, we are going to continue the interesting discussions that we started yesterday. So yesterday there was the first panel devoted to one of the projects, scientific project that we are involved in, and then there was a very interesting workshop on ChatGPT delivered by Dr. Paweł Kowalski. But today we are going to continue both scientific panels and then also a second workshop, this time again on using generative artificial intelligence by lawyers, but from the perspective of our ethical requirements. So let me share just 2 words with you about the involvement of European Bar Federation in scientific projects that this event is part of. These 2 projects are SCAN2 and CREA2. Both of them are financed by the European Commission. We are part of the consortium team, responsible mostly for delivering the efforts of the scientific group to the general audience, means actually you. So this opportunity is a chance for us to know the results of these 2 projects. The first one, SCAN2 project, is devoted to the digitalization and simplification of very specific European civil procedure, which is a European small claims procedure. And second one, CREA2, is about using advanced technology, including artificial intelligence, to resolve civil disputes. And today we are going not only to witness the presentation of the members of Scientific Consortium, but also a short presentation of a platform that was already built in SCAN2 project. And you will be first one experiencing this platform, and we will also want you to share your opinion and suggestion about it. So there will be a survey. That's just an announcement. Then I will give the floor to the responsible person, to Paola, to let you know more. But without further ado, let me introduce the moderator of the first panel today, second panel in our agenda, who is Marco Giacalone, a researcher professor at the Private and Economic Law Department and co-director of the Research Group on Digitalization and Access to Justice of VUB University, Belgium. That's the person who actually has a great experience in digitalizing access to justice and the whole legal sphere. So clap our hands to Marco. Let me also share that Marco is a coordinator of those 2 scientific projects that we are involved to. So I give the floor to you and let you introduce our speakers.
Thank you. Thank you so much, Maria, and well, Isabella as well from the Fédération Barreaux d'Europe. And well, before starting, let me also thank you, Fernanda, Sandra, Anna, all the staff involved in the behind the stage. And yeah, let's start the first session of today. We have a very international and mixed panel. So here I have just a few, but I can invite also the other 3 to join. So Mattia, Daja, and Thomas. So we will start this session is really about the automation and artificial intelligence. Comparing to yesterday, there is like a different aspect, and we have like some panelists that are from the project that we were talking about, and some others that with specific cases. So let me introduce the first speaker. Antonio Mendes Oliveira is a judge of the administrative and tax courts, and is working in a very interesting reform, like the administrative jurisdiction reform and tax jurisdiction reform. And he will introduce the case of the electronic judicial procedure. So, Antonio, the floor is yours. What you prefer? You prefer to stay seat, or you prefer like these two options?
Well, probably I can see better from there.
Okay.
Excuse me.
Yes.
Thank you, Mr. Speaker. I would like firstly to say that I'm very thankful and very honored for the invitation. I will not talk a lot about AI. I'm sorry, because I thought that was that will be covered by more knowledgeable people than me. So I will talk about another thing. I don't know if it's possible to put my presentation. I will talk. Okay. Can I send it real quick? Yes. So I'll talk about without and then I'll show you. So here in Portugal, and particularly in the administrative course, we have a very fully implemented electronic judicial procedure. This means that the procedure. Sorry, do you want me to give the email? Eu enviei ontem por e-mail, mas... Okay. This means that the process runs fully on a system. In our case, it's called the CITAF. George knows it very well. And it's fully electronic. That means that all parties communicate through the system. All papers are submitted through the system. And there are other things that the system can do. The system also records the hearings that can be shared with the parties. Oh, here it is. Much prettier than just talking like this. And I've come aware, talking to other colleagues in other countries, that this is not the case in every European country. So I thought it was interesting to show you a very brief overview of our model. Firstly, the evolution of it. We started out with a photo definition, a simple digitalization of the documents, and inserted them into the system. From there, we evolved to the second phase, the one that we are actually in, the e-process part, that when the judicial procedure becomes fully electronic and adapted to this electronic environment. That means that all documental procedures are fully digital. The hearings can be performed with digital resources, and the notion of an electronic procedural system takes center stage. The electronic by default, which means that the regulations of the procedure are thought of not in the old logic of the if you want an analogic process, the one that was made by mail, but instead it's thought of in the electronic view, adapting to this new model. The third generation that we are eventually arriving, it's when the case and the system, it's fully connected to the internet. So you can take things directly from the internet. You can have documents that are directly in the internet, and you can have an interaction with both the judge and the parties with other means rather than the ones encapsulated in the judicial procedure. Well, I don't know if I'm pressing this right. Okay. So this is the actual definition of the electronic judicial procedure, the one that I told you about. And those are the foundations and reasoning. So on the one hand, you have the principle of digital by default, which means that the whole procedure is thought of in that electronic environment. You have the goal of effectiveness and efficiency, which means that we can use that system and the fact that it's fully electronic to make it more streamlined, more efficient. And that's the part that I wanted to talk to you about. You have the arisal of new principles, new procedural principles that are unique that stem from the electronic nature of the procedure. So I've chosen these four: dematerialization, dematerialization, connectivity and immediacy, and hyperreality. The first one, it's deemed the most important. George has worked extensively in this one. This is the one, simplifying, that feeds the data to the system. So it's a principle that the parties have to submit all the data in the system so the system can operate properly. This is also the bridge to the future implementation of AI in judicial decisions. If we don't have the data, we cannot have that support. So this is the most important principle. The second one is very interesting for us judges and lawyers, and I hope you don't hold it against me being a judge. It's the fact that if it's electronic, the old notions of territory don't have the same weight that they had before. So you can challenge certain things that we taken for granted. For instance, we can challenge the case of extension of deadlines for territorial reasons. Why should we? If it's fully electronic, does it make sense to maintain these kinds of procedural rules that were thought of in a different way, in a way when the process was fully implemented by mail? Also, if you don't have the same territorial boundaries, does it make sense not to redistribute processes if you have a court that has a lesser backlog and then can help the efficiency and the speed of decision in the whole of the system? Those are some lines of thought that I wanted to share with you. Connectivity and immediacy, well, those are no-brainers, and they refer to the fact that the process is instantly and constantly available to all parties. This can also lead us to challenge certain things like the extensions of the business days and some things that were also taken in the logic of the old process. And the one, the more flashier one, if you will, the hyperreality. And this one refers to the virtual hearings, the possibility of taking a virtual hearing, not just the judgment hearing, but also the pre-judgment hearing, and the fact that you can record the whole hearing. And to me, this is a point and a principle that has a lot of weight, because if applied correctly, this means that you can change, or better yet, enhance the capability of the higher courts to review the decisions of the first courts, or the decisions of the first courts, which means that if they have access to the extension of the hearing with audio and video, they can see better for themselves the evidence that were produced in court and can take a better decision in second instance. Also, and we have some examples of this in the United States and in Brazil, there's a case here, and I know it's not an open and shut case, but there's a case in here to advocate for the diffusion of those videos, of those court hearings, to promote public access and transparency in judicial procedure. So the conclusions, and I made this up to be the quickest as possible. The conclusions are that the electronic judicial procedure arises and entangles new principles, new unique principles that have a connection, that are operative by themselves and have a connection with all other classical judicial procedures principles, such as due process, equality, equal treatment, adversarial system, etc. However, we must think of this in an integrated way and in a pragmatic way. So if we have an electronic judicial procedure, we have to make rules that are fit that electronic nature of the process. So you cannot continue to think in an analog way when you have a fully electronic procedure. That affects all of the process, all of the parties, the judge, the court clerks, and others. I leave you with a text that some colleagues and I have made about this. We also talk about the test of these principles in the context of COVID-19. And it's very interesting because we collected data from the Ministry of Justice, and we came to the conclusion that these principles worked and in fact saved the administrative courts during COVID in a manner that they had a higher efficiency during this period, exactly because it was fully implemented, the judicial procedure, they fully implemented the virtual hearings, and I think that's a case study worth noting. Thank you very much.
Perfect. Thank you so much, Antonio. And let me pass now to the second speaker, Jorge Da Ponte. I was very fascinated by your CV, Jorge. So he started with the bachelor degree in computer science. Then he worked with several experience between like working on the registry of notaries, and then he's now like the main person for the project Justice Digital Platform, the Portuguese one, so justica.gov.pt, and actually is one of the main person, or like the main person that is revolutionizing and then is using a lot of AI into the local program. Thank you. From there? Yeah.
So good morning, everyone. Thank you very much for the introduction. I'm currently also the Vice President of the Portuguese Registry Institute. And so thank you very much for the invitation from the Barreaux Association and so on. Let me start. Yes. Okay, sure. Yeah, thank you. So to start, I think it's crucial to clarify the foundational concepts that drive the transformation that are currently occurring. So the topic of this conference is digitizing justice, but I think it's crucial to define these three concepts: digitization, digitalization, and digital transformation. So these terms often occur interchangeably, but they actually represent distinct stages in our journey towards a fully integrated digital justice system. Digitization refers to the converting of information from analog to digital formats. Digitalization implies the use of digital technologies to improve process, and digital transformation encompasses the broader cultural, organization, and operational shift. My presentation, titled New Architectures and Interoperability for a Digital Justice, is a testament of these concepts. We are not only transitioning from paper to pixels, but also reinventing our process and systems to be more efficient, accessible, and responsive to the needs of our citizens and legal professionals. The need to adopt sustainable technologies for modernizing the technological landscape of the Ministry of Justice, encompassing courts and administrative services, is more critical than ever. Our aim is to enhance efficiency for both professionals and citizens. This involves embracing new architectures, but that are not only robust and scalable, but also user-centric and intuitive. The challenge is how to bridge the gap between the law and technology for a more efficient and transparent and accessible judicial system. We are witnessing an evolution of the legal tech landscape through e-courts, the Portuguese e-tribunais in Portuguese, and online legal procedures, utilizing digital platforms for court procedures, filling legal documents, and managing cases. The alternative dispute resolution online platform facilitates the access to justice and speeds process and procedures. Additionally, digital public registry and electronic civil identification signify a leap towards a transparent, secure, and user-friendly system that serves the public while safeguarding their identity, property, and registries, making the data more accessible to the owner of the data. In the digitization phase, our focus is centering on managing data with the utmost integrity, confidentiality, and reliability. This commitment is key to fostering legal confidence among citizens, professionals, and institutions, reduce the dependence on human interaction, on tasks and processes that are suitable for that, and paperwork, streamline processes, and enhance service delivery, increasing the integration and interoperability of systems and data, and provide real-time access to information. Investments are being done to upskill our workforce and update our IT systems, application, and tools. Such investments are not only expenditures, but are critical to ensure our success and upgrade the technological backbone of the justice system. That materialization of process, registry, and acts can only be achieved through a meticulous designed data structure that ensures seamless communication between services. This structure is the backbone of our data integration efforts, facilitating an internal layer of automatic updates and data flows that are nearly real-time. This integration is crucial for maximizing process efficiency and elevating the service levels. Furthermore, service automation is pursued to the degree that the complexity of the process allows, with a keen focus on safeguarding data security through meticulously cross-checking and controls. At the ERN, at the Registry Institute, we are structuring the data for every business area. So civil registry, business registry, land registry, and cars registry. Because structured data allows us to build better services. And we are implementing automation across business areas and processes so that repetitive tasks are done by machines with human supervision, and validations and cross-checks are done automatically. So the future will be human-driven and AI-accelerated and not the other way around. So interoperability is key to all the things that we are doing. It's a key to an efficient information exchanging of data, to enhance access to justice by enabling a more integrated, user-friendly, and suitable interface. The consistency and standardization of data also helps. It has a high cost effectiveness. It improves case management because more data is available for the people that has to decide. Data and security and privacy is a key component of course, on this. Scalability and future of adaptation is also a key in this process because the future is also API driven. And so these new technologies that are emerging are hoping that when they emerge, there are APIs that can be used to exchange data and to speed up the process. In summary, interoperability is not just a technical necessity, but also a strategical enabler for a more efficient, accessible, and responsive justice system. We are currently already doing a lot of interoperabilities. The new e-courts, e-tribunal in Portuguese systems, has a lot of interoperabilities already done, not only inside the Ministry of Justice, but also with other entities from other government bodies. And when we look at the architecture that we are building, this is the conceptual architecture of the registries. We are seeing on a way to do a multi-layer architecture with several layers that are connecting, that are speaking with each other. So beginning with a user-centric consumer layer that provides various channels for end users, including web, mobile, and chatbots. So we must be where the user is and we have to deliver technologies that the user wants to use. The core service layer and the core data layer are they provide the backbone of services and data, ensuring that our civil, commercial, property registries are robust and responsive. The infrastructure layer that we are currently transitioning towards a cloud, an hybrid infrastructure with cloud solution, increasing our ability and resilience. The layer of transversal solutions like digital signature, video conference, AI, and so on, are enabling all the processes to run on a same and similar way. Data analytics is something that I will speak in a minute. It's something that we are also building a new data lake, and also an integration layer, of course, for the interoperabilities and also to provide security for all of the system. This multifaceted architecture model not only streamlines service delivery, but also lays the ground for a justice system that is adaptable, secure, and ready to meet future challenges. But the implementation of this architecture must also be accompanied by a refreshed service model. Digital by default means that all services that are available by RN to the public are available online. But we must also refresh the public office, the in-person attendance that must be available for all those that need, because they have special complex process or to prevent cases of digital exclusion. So with this introduction, let me speak about success stories and projects that we are building, already built, or are building inside the Ministry of Justice. Starting with a remote service platform. This is a platform where not only notaries, but also lawyers and solicitors can speak with their clients and provide authentic acts. So this is certified. All of the people that are logging in the systems are logging with qualified certificates, and they can do a lot of acts. For instance, divorce. Currently in Portugal, we are enabling divorces through video conference with both of the parties. There is a process, the procedures. In the end, they sign with an electronic signature the documents, and so they never meet in person. We want to improve this platform with the summarization and validation of acts automatically, so that these parties can have an explanation by the systems of what happened in the video conference. All of the sessions are stored and saved and stored for 20 years for legal procedures. The Judicial Practical Guide chatbot. This was the first bot implemented after ChatGPT was launched. It was the first, according to Microsoft, was the first project by a public entity in Europe using this LLM model. Currently, the bot is a specialist in weddings procedures, divorce, and business registry, We are currently improving the model so that it can answer questions related to alternative means of litigation and criminal registry. And we are indexing a lot of data from the Justice digital platform so that the bot can be always active and know what's going on. This is also the first initiative from the GovTech strategy that was launched by the current government. The online request of Portuguese nationality, it's available for professionals to submit cases on behalf of their clients, where they can upload all the necessary documents, and there is a process that validates with AI, validates the documents, if they are readable, it's very important, and if they are the document that is needed on that kind of process. This AI is done with a convolutional neural network that was built by a small startup that helped us building this service. And it has a lot. There is the process validates the document, and then the user, ERN user, will confirm or decline the validation that the process provided. Anonymization of court sentences. We have a model running on our own servers that will do the verification of entities on court sentence and the anonymization of those entities. This is very new. It's been working from ICFES from the last 2 years. Yes, Jorge Barreaux is the head of this project, and it has a lot of externalities, because with the right model analyzing court sentences, then we can not only do anonymization, but also integrate with a lot of other uses of the data, compare data, cross-check data, and so on. ERN is building a data lake, but also the other public body from justice, the DGPJ, is also building the justice data lake, where we are going to integrate our data. The aim is not only have a simple analysis of data, but also do statistics, operational indicators, interactive dashboard with predictive capabilities, scenario simulation, and active bias detection. This is a conceptual logic architecture where you can see most of the data lake will have some architecture like that. And this is an example that we are already implementing, that are crossing data from the legal person registry, business registry, with the industrial property registry. So we're going to see the companies that are active or not active on business registry, if they have intellectual property, if they have industrial property, trademarks, patents, and so on. The aim is to continue to improve, bring the data to the data lake from courts, compare with this data, cross-check with the data, then bring the data from, for instance, land registry from our registry, and compare and see those entities that have a problem in court, that are insolvent or whatever, what kind of property they have automatically, because the data lake, the model behind this data lake provides these answers. And if you also want to integrate data from the police, you can also cross-check everything. On top of this data lake, we are going to build a lot of dashboards. This dashboard is not on top of that data lake. It's an example of a dashboard that is already presented through the eCourts system that shows what's happening on the systems. I think this is the number of sign process in the system from 2020. So a lot of indicators are going to be available for judges, for clerks, for the government, and so on, and for public also. This is an example of other dashboards, completely different from the citizens card operation. So we have a lot of people renewing the citizens cards. and we can see when they arrived in terms of the hour that they showed in the ERN booth, what kind of booth they went, what kind of procedure they've built, all on top, and cross-check every office to see productivity levels and so on. So we're already having this as a tool to manage better our service. The courts ecosystem, so we integrated all of the tools that were used by judges, the judicial magistrates, judges from the administrative tax jurisdiction, public ministry magistrates, clerks, professionals, and so on. We have a similar ecosystems where we are going to continue to deliver more services where everything integrates on that integration layer that I've talked about. And for an end user, there are a lot of attention to this level. They are able to access electronic notifications, case inquiries, and so on. So everything currently is improving in this way. I'm almost finished. Just two more examples. New citizen cards. In Portugal, since 2007, every Portuguese citizen has a card with digital sign abilities and authentication. We are currently upgrading this card with contactless capabilities, and so new use cases will be presented that are managed and delivered by justice, like use your citizen card in transport, in banking, healthcare, and so on. And the last one, a new platform for registries. We are starting with service to companies. So in March, we'll hopefully launch this new platform with better user experience, like the courts have, with AI to provide better services. Currently, we already are integrating AI with a business name generator. So this was before ChatGPT. We were using GPT 2.0. That's a model that is open sourced to generate names to speed the registry of companies. Also with a user intervention and supervision. And so this all that I'm talked about is not easier to do. There are a lot of needs to speak with stakeholders, to integrate stakeholders on these challenges, on defining all of this process and new solutions. There are also challenges on cybersecurity, data privacy, and so on. But I think we are currently on a good path to tackle all of these issues. Thank you very much.
Thank you so much, Jorge. And yesterday we talked a bit about this SCAN project, and we would like to take your attention and try to show you in a few minutes how this platform works, and then ask your help for a very small feedback and evaluation about it. So let me ask Paola to come and show you briefly how does it work, this new platform that we are building up. So this is about this cross-border procedure regarding small claims, so claims that are until 5,000 euro. And there are forms available on the Justice portal. We're trying to do something that is a bit simpler, more digital, and I let you show to all the people here.
This.
And then with the easy QR code, we ask to just give an evaluation of what we will present.
Okay, thank you, Marco. Thank you all. Okay, today we're going to put in practice what we learned yesterday. So I will start by sending you a QR code, by sharing it with you. If you please can all try to come a bit nearer our screens just to check a bit more the visibility, because it's very important for us to have your feedbacks and check if you can see very well the screens, okay? Because I'm going to make a real simulation right now with all of you. So after some QR codes will be shared with you, and after we will ask you to answer a questionnaire, and we will do it together. But first, our platform. So just to remember about yesterday, we talked about the small claims proceedings, and today we will imagine we are all consumers, okay? Now we are all, let's imagine, I am Italian. So today I am an Italian consumer seeking to collect a debt from a small business in Belgium. Let's imagine I went to Belgium, I bought this very nice jacket, but I ordered it online, but they didn't, I never received it. So I'm a consumer without a lawyer. I would like to collect my debt. How can I do it? With our platform, you can do it entirely digitally. So we go to the platform, you sign up, you see, make sure to enter the prefix before the username is indicated in the instructions, because you can be a lawyer, you can be a judge, or you can be a consumer. Today we are consumers, that's why I will put my name. Okay, next step. Okay. Here you can invent everything, because we don't need your data. So that's why you can invent to be whoever you want to. But when you start the presentation, you must feel, of course, you are the claimant, you are the consumer, so you must fill the information in order to start the claim. Okay, that's why you're asked to. But we don't need data, that's why I'm inventing them right now, just to pass. Okay, so then you go on claims, submit new claim. Okay, you are the claimant right now. Fill form with my data. That's why I inserted them before. Okay? So street number, I'm going to invent, I live in Piazza di Spagna in Rome, the wonderful. Okay, Rome, Italy, email. Okay, defendant. I bought it in Brussels. That's why I need to add that it's Louise Boutique. So it's a boutique that you can find in Excel, in Brussels. It's an Avenue Louise. And you insert the details that you know, okay? Then you have jurisdiction. On what ground do you consider the court to have jurisdiction? You are just a consumer, but you have the indication here. Your application must be lodged with the tribunal that has jurisdiction to deal with it, in accordance with the rules of Brussels 1 bis regulation, and there's a direct link to that Brussels 1 bis regulation. If you're not sure about it, you can also link on the website of European Judicial Atlas. But you may also make an error. It's not a problem. Here you just prospect a possibility. Nature of the case, country of domicile, I'm Italian, so of the claimant, of the defendant, it's Belgium. I think it's Belgium, I prospect it, and I put it in. So next, I claim for money, yes. The amount, 1,000 euro. And then, yes, I claim the cost of proceedings. I think it's 500. Are you claiming interest? No. At the moment, no. Interest on the cost? No. Okay. Give reasons for your claim. Explain what happened. Okay, I bought a coat in online, we said before, and I never received it. Okay. Written evidence, yes, I bought it, so I have my ticket. No, I have no witnesses. I was buying it alone. Okay, oral hearing. Do you want to be heard? So do you want an oral hearing? No, I think it's not relevant. If the courts decide to hold it, do you want to be physically there? Yes, why not? Maybe it's a good chance to be heard. Okay, do you agree to the use of your electronic means of communication? Yes, I don't want to go anywhere. I just want to be home and have access to justice. Do you agree to the use of electronic means? Yes. Do you want a certificate from the tribunal? Yes. Done. This is my signature. I'm gonna write like this, but here you need to put your digital signature and the day of today. Then you prospect the country. Justice, juge de paix. Place Louise. Okay, so here's the preview. Claimant, defendant, jurisdiction, cross-border nature of the case, claim, and we ended it in 3 minutes. You finished everything in 3 minutes, and then you submit it. Here's what you see there. Okay, so we started the proceeding. It's pending right now. You will have more time for clarifying it. If you have time, 3 days to clarify it. Then, if the judge approves, you will get evaluated, then resolved or rejected. It's easy this way. You can do everything online, digitally. You don't have to print any form, sign any form, then go back, scan them, and give back to the judge or the justice of the peace or the competent judge in your country. So this is why we mentioned that we wanted to ensure a digital answer. So now I invite you all to please take a picture of our QR code with your phones. I invite you all. I've also shared some papers. When you all are ready, we will start our questionnaire. Can I get a big yes? Are you ready? Yes? Okay. Okay, then. Can you follow on your screen? Okay. So the first part, you will indicate how much you know technology. Okay, for an average, I am young, so I'm from 26 to 35. You can answer whatever you want. I'm a female. I got my doctorate. I'm a lawyer as well. Okay, the relationship with technology. How often do you use for personal needs online application? Me, every day. Also, I always use technology because I study and work with my computer. My digital skills are high, very high. And my level of familiarity with technology is very high, and innovation as well. I always use online application, and digitalization I think it simplifies legal proceedings. Of course, you can give your own answers. I'm just going directly to the second part. Okay, knowledge of European small claims procedure. How familiar are you with cross-border small claims procedure? I study them and I work them, so that's why I would put 5. But if you don't, put a lesser amount. How much experience do you have with the direct use of this kind of procedure? Well, me, I'm very familiar. How much experience do you have in supporting a consumer who is compiling the forms of this kind of procedure? If you don't have very much, put nothing. Put 1, 2, 3. It's not relevant. But now we really need your opinions about the features in the ScanShoe online platform. Of course, I'm not going to evaluate myself alone, so be honest, tell what you really think about it. So how do you rate the presence during the compilation phase of Form B and Form D of the automatic system to detect incomplete sections or fields in the digital form? I'm referring here to the ones to specify when I had to add some other informations. That's why if you want to add more, you can fill that space. And you will say if it wasn't helpful or very helpful. How do you rate the automatic filling of some sections of Form B and 4D based information already handed before? It's related to the first one. How do you rate the presence of graphical visualization which signal the progress of the completion of the form steps? It was up on the bar, pending, accepted, so that you can always see in any time the time of the proceedings. How do you rate the presence of graphical elements to inform about the progress of the claim? So I think that I would like to use the ScanShoe platform frequently. I found the ScanShoe unnecessary complex. You need to tell me if you find it hard to understand or if you find it easier to understand. I thought the ScanShoe platform was easy to use. I strongly disagree. I think that I will need assistance to be able to use the ScanShoe platform. So if you need someone that needs to help you, or you can do it alone, you can choose whatever you want. I found the various functions in the ScanShoe platform were well integrated. Yes. I thought there was too much inconsistency in the ScanShoe platform. I would imagine that most people would learn to use the ScanShoe platform very quickly. I found it very cumbersome, awkward to use. Strongly disagree. I felt very confident using the ScanShoe platform. I needed to learn a lot of things before I could get going with the ScanShoe platform. Of course, if you're not used with these proceedings, you may also hear insert that you strongly disagree. But even if it is your first time, really, I don't think it takes a degree to understand the way it should be done. It's really for consumers. So we try to use very good text simplification and all this kind of information. But it's up to you, of course. So then I'm gonna send it. Okay, so that's why I really hope you made your conclusion and you sent us all the feedbacks. If you want to put some more information in just the last question, we will be very happy to collect your answers, your feedbacks. And if you want to add something, we are here today, but you can also write to us. And please check our website, scanshoe.be. It's our project website where you can see what I talked about yesterday. So a little summary on each country where you can see the applicable law, competent court, and legal fees. It's very easy and you can use it for evaluating the platform as well. Thank you for your attention.
Thank you, Paola, and thank you all for your very important feedback for the conclusion of this project. Just like as a final reminder, next month we are organizing the final conference and showing this platform to everybody. So you are really the first now evaluating it. Then the platform will be showed and open to the public from the end of February. We have a conference really focus on this on the 22nd and 23rd of February in Brussels. Okay, so we finished with this and we started with our second project. It's called CRIA2 project. It's about the conflict resolution just in division of goods. So when there are like division of goods in inheritance, in divorce cases, we are developing some algorithm that can facilitate. And then now, especially in the session of today, we will also speak about a chatbot that we are developing using generative AI. So connected to the workshop that yesterday was organized by Pavel, that I see in the public, we are not focusing on ChatGPT, but we are trying to make our own chatbot, of course, open source. And well, I will just give now the show, like the word to Mattia. Mattia is our IT person that is realizing this chatbot together with Professor Flora Amato. Mattia is a researcher. He got several awards. He also worked at Apple Academy. And then now we are very happy to have it in our team. And he will show you with some slides how our chatbot is working related to our project. Thank you. We try to ask like all the speaker now 10 minutes in order to be fine with the coffee break.
Okay. Good morning, everyone. I guess I'll wait for the presentation to show up. In the meanwhile, can you hear me? Yes, I guess so. So in the meanwhile, I'll just, introduce myself. I'm Mattia Fonisto, and I'm an AI researcher currently working for the University of Naples, Federico II. And together with Professor Flora Amato, we are handling the more IT side of the CRIA2 project. And today I'm going to show you how we are doing that. So, okay. So the objective of today's presentation is to deep dive into how we are building a content-based generative chatbot with reasoning capabilities, able to make easier for people who are not familiar with the legal jargon to access justice. And by the end of this presentation, I will show you a short demonstration of the current work in progress by means of some screenshots on the topic on the division of assets after divorce, exploiting all the different topics that I'm going to cover briefly. It will be a little bit academic, so bear with me. So this is the overall architecture that we are developing right now. So it could slightly change by the end of the project, but this should be like the overall architecture. So the main idea is that a user who is not familiar with the legal jargon asks the chatbot a question related to conflict resolution during divorce or inheritance for a specific country of the project. And then the chatbot should be able to provide factual help to the user by intelligently integrating documents from our trust legal knowledge base that the legal team of the CRIA2 has been creating and populating. So first main component of this architecture is the large language model, which can be seen as the brain of the solution. So it is the component that actually handles the generation of the text. So quick overview of what is a language model, and then we'll go to large language models. So language models are models that are able to assign probabilities to sequences of tokens or words. Maybe that's a better way of telling them. And where the probability tells us how good a sequence is. So on the right side of this slide, I hope you can see that I just provided you with a really small example. According to such a vocabulary of 5 words, so the sentence, the court found the defendant guilty is way more, is a higher probability when compared to found guilty the defendant, the court, which is a sentence which does not make sense. And by exploiting a property of such models, we can use them to actually generate text and not just assign probabilities. And that's what we do, essentially. And a large model, in comparison, is a huge language model, which has a way more parameters. And this is trained over, like the entirety of the internet, or like these really huge archives like Wikipedia or GitHub or whatever. And just to give you an idea what these models are, how big these models are getting in time, you can just take a look at this table and just stick to, maybe the one from OpenAI. Maybe you are more familiar with them. So starting from 2018, we went from hundreds of millions of parameters up to, in 2021, to hundreds of billions of parameters with the GPT-3. And, these models are getting even bigger, and, the things are really getting, out of hand quite quickly. So when it comes to the second component of this chatbot, which is like the real novelty of this solution, it is the reasoning framework. And this is what makes the LLM make reasonings and take action. And by taking action, we mean retrieve the content that it needs, whenever it wants to. This framework not only makes the solution more reliable in terms of the accuracy of the responses, but it also gives it a layer of transparency, since both the reasoning behind the response and the source of information that such a chatbot is using is known, since it is transparent to the end user. And I'll show you by the end of it. So a quick step back, what is our reasoning framework? It is like a really complex prompt engineering kind of strategy. Here, maybe also according to the yesterday workshop on ChatGPT, we know that prompting is essential in the quality of the output that we expect. And, just to give you a really small example, one of the prompting engineering technique, the most used ones, which is also one of the simplest one, is called few shot prompting, which consists in just giving the language model some examples prior of the actual question that we are, asking. And in this case, it is able to perform sentiment classification, just by providing 3 examples, which is like a huge success for such, a small kind of input. And when it comes to a reasoning framework, actually this reasoning framework, which is called Reason plus Act, or REACT for short, it takes like the idea of prompt guiding to the next level. And what it does is it makes the LLM able to reason and to take action, as I told you before. So it basically forces the large language model to generate text in the form of thought, action, and observation, where thought is like the intermediate question to answer to get to the final answer, of the user query. Action is the information retrieval action to perform in order to get the piece of information that we need in order to get to that answer. And by the end of it, we have the observation, which is like the retrieved content used for the generation of the intermediate response to intermediate question. And lately, OpenAI also admitted that this kind of agentic way of creating chatbots is really powerful when we are dealing with content-based chatbots. So that's pretty much what we are doing right now. And third component is basically how we provide the relay, the relevant content to the chatbot whenever it needs to. So what we use is something called text embedding model, which is a model able to project text into a higher dimensional space that has this kind of property, which is 2 vectors within this space are close together if their semantic meaning is pretty much the same. And here I provided you with an example on the right side. I don't know if you can see that pretty well. Maybe you cannot. I'm sorry for that. So in here, we are looking at a model which is called Word2Vec, which works just for words and not for sentences, but the intuition is pretty much the same. So what I did here is I kind of centered this image around the word law. And what we have here, I like the 100 neighbors of such a word. And as you can see, there are all, the words that we can see, even though maybe you cannot see them since they are like really small, are like banning, federal, charge, property, all words that are used, along with the word law, and that maybe share the same or like a similar semantic meaning. And, if you take this intuition and move into sentences, it's pretty much the same thing. So what we do here is we take the intermediate question, we look for, the relevant document according to such embeddings, and then, we provide it to the model and, we let it generate the intermediate answer up until, it gets to the final answer. But we'll get, I guess, way clearer by the end of it by the demonstration. And lastly, the last thing that we're going to talk about as a component is where we store such embeddings and where we store such documents. Since, traditional database do not work properly with such entities, since, they are not structured to perform, this kind of operation like similarity search over floating point vectors. So we are sticking with something called vector databases, or vector stores for short. And, also since this kind of databases have, primitives like similarity search, or like matching based on a distance metric, which really work nicely when we have to get the relevant content for each and every query. Just to give you a short example, if you think about the exact search, and maybe we want to compare two sentences that share the same semantic meaning, they could be written in like in two completely different ways. So exact search will never work properly. So what we have to do is we have to stick to embeddings that hold in some way that we cannot explain, like two sentences that share the same semantic meaning. And on the right side of this slide, I wanted to provide you with, a projection into these, just to give you the idea. So in this case, the orange dot is the query embedding, while the red dots are like the document embedding. And if I were going to assign to that query its relevant content, I would assign the one highlighted since it is the closest one in that space. Of course, the real space is like 1,000 dimension. We cannot visualize it, but just to give you an idea, this is how it works. And here, I'm going to show you just some screenshots. The user interface is really simple and bare bone, just to give you the idea. This is the current work in progress. So what we do here is, at first, we greet him, and he goes like, okay, hi, what can I assist you? And then I go like, what is the dissolution of communion? In this particular case, we are just sticking with the Italian civil code, just, to get a really nice and simple example. And what it does here is, just as I told you, like it generates the thought and goes like, okay, this sounds like a legal term. Maybe I should use this tool to find an answer. And what it looks for is the tool regarding the division of assets in Italy, since he understood that I was referring to Italy in this particular case. And it goes like, okay, let's see what can I find with this solution of communion. And the highlighted text box is what he actually finds. It's just a summary of it, just to give you, a better way of looking at it. And by the end of it, it also goes like, okay, this solution results in the division of assets. And the next thought is, it does not provide this as an answer. It goes like, okay, this seems relevant, but I should continue searching to make sure. So in order to provide like a better explanation of what the user asked. And it goes like, okay, now I search for the division of assets after divorce, and it gets these other piece of information from our trust legal knowledge. And, it goes like, okay, then the dissolution communion refers to, blah, 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 whatever. Okay. So the point here is we have a trusted knowledge base, which have been built by the legal team of CREA2. And, the reasoning and the source of information that the chatbot is using is known by the user, since, we give them, we make it transparent, which gives a layer of explainability that traditional, like also ChatGPT does not have. Even, during the workshop, as you saw, even though you pass them maybe PDFs or like external data sources, you don't know which is the piece of information that it is using in order to generate that particular answer. In this case, we are actually doing that, and we are also, forcing the model to tell us, okay, what is the reasoning behind, the generation of the response that you actually did. And here, what I did is just another example to give an idea, but it's pretty much the same as before. So I was like, what is the difference between personal property and community property? Maybe it's a dumb question, but I'm not a legal guy, so for me it was not obvious. And what it does is it first looks for personal property, and then the second thought is, okay, now I have to look for community property. It takes these two information, it mixes them together, and this provides this answer, which is like personal property and community property are two types of assets, and and et cetera, et cetera. And that's pretty much the end of the presentation. Thanks for listening. If you have any question on your class. Thank you.
I know that it's a bit more challenging to follow a guy like an IT guy, but I think it's also crucial for us to show a bit how does it work, this chatbot for this project. Now we will turn to other two intervention about this project, but I think way easier to follow. So let me introduce Thomas Eriksen. So Thomas has a background in legal informatics. He works many years also as a linguist and work on the translation of legal text and contract. And he joined our project from Taltech University, Tallinn, Estonia. Thank you, Thomas.
Yeah, thank you very much for the invitation, and a particular thank you to Dr. Hoffman as well, who brought me into this project to begin with. So what I would like to speak to you today is essentially my views on some of the developments that might be necessary for the legal industry as a whole, and in light of these new developments that we really have heard about so far. Does this work? There we go. So one thing that I would like to really specify is the potential for new market segments that AI can actually provide. And because something that I have noticed during my studies and my experiences with this project and in other things as well is how many people actually do avail themselves of legal services. Because I believe there's a huge untapped segment of people and businesses as well that don't really use legal services of any kind because the law is intimidating. So one of these anecdotal experiences is I am a co-founder and was on the board of directors for Sarepta Studio, which is an indie games company, and we won a BAFTA, I was pretty proud of. And throughout these 11 years that I was sitting on this board, I think I can count on one hand how many times we legitimately considered using legal services for anything. And ultimately, it's even less the times that we actually did do so. So it's really seen as a kind of an extravagance, and it's a kind of a matter of last resort because you really want to avoid spending any money, and even just approaching a lawyer can be very intimidating for many companies. And that is not just an anecdotal experience either, because I feel this kind of mindset, at least in the Nordic countries, is very much a reality across many industries. And this also goes for I would say normal people in like middle-class households in the Nordics, because I grew up in a very distinctly non-academic background. So it was this, even talking about the law is just something that people don't do, which is like, to lawyers, for us it's pretty commonplace, but for most people it is kind of impenetrable, and there's a high obstacle to even get started there. So this ignorance of potential and rights, especially for claims, it is why I'm really very heartened to see both the examples that have been brought up from Estonia, and also these projects that we are now just discussing very much in detail, because I honestly do believe that is going to help society as a whole. So yes, how can I help in this? I mean, we've seen examples of this, but this basically goes into some of the workshop that we did yesterday. So just increasing labor efficiency, and that which will reduce costs and possibly give fewer billable hours per client. But I believe that this can be used to bring more clients. So how do we do this? We can use AI as a client outreach tools. And for instance, Crea and Scan and many of the other tools that we have seen so far is a great example of that, right? Because it makes information gathering for clients easier, and not just easier, but also cheaper. And some of them can even be free. And that will possibly, or at least hopefully in my mind, actually give clients the ability to engage with the law in a way that isn't so intimidating, that isn't so full of jargon, that is, you can kind of use these natural models to understand what your position is as a layman. And I believe that's very important. And ultimately, which is how we kind of started this entire talk, is it still requires genuine people. Like actual lawyers ultimately are the people who are needed to do the real evaluation at the end of this. It's more a case of getting people more interested in law, and or at least their position within the legal system. And so positive side effects of this is it's access to real justice, as I would call it, because it means you can actually engage with the real law instead of bypassing it. There's been a lot of talk over the recent years of trying to increase access to justice but that's the main aspect of that has been things like ADR and things that, you know, kind of tries to bypass the written law. And I think that's possibly a damaging thing. I'm not entirely convinced of the American approach where settlements is everything, essentially. And yes, so unlike ADR, it actually engages people in it, and it also ensures that legislation as it is written becomes more important. And I think that's more of a European idea and an ideal to or at least civil law as opposed to common law ideal, where the law is supposed to be used much as a civil as a social guideline, where but then you have to make it accessible, and that's really where I think this can help. So part of the obstacles, I believe, is depends a little bit on the country, but there is a inflexibility within the legal industry in general. There is some corroboration. This is from a research paper from 2 years ago, where if you look at the last sentence, it says that most law firms or most law firm partnerships don't want to change. They aren't good at it, and by and large don't think it's necessary. Even though I think we see here that people are becoming open to it now after 2 years, but I still think this keeping this mindset going is going to be very important for as we go forward. So how is this relevant in terms of the experience that I have made so far? Some previous experience, I feel like, as it was introduced, I do have a little bit of a background in legal informatics. That's basically what is called legal tech today. But back in those days, it was much more oriented around things like, oh, you have to learn to be a programmer as well as understanding some law. But now, with the technology being more developed and more easily accessible, you don't really need all that in-depth tech knowledge anymore. I mean, in fact, you can use GPTs to help you program now and create models, at least, even though they aren't necessarily the final product. So it is a relatively new field, but it's also, what's interesting here is, to me at least, in terms of our role as legal professionals, is that these cross-disciplinary aspects and roles in within the legal industry is really becoming more and more important. And I think actually being on top of the tech industry, at least on a macro level, is going to be just as important as staying on top of the legal industry. And so, yes, this is, I call it a Janus approach, where you have to be a double nerd. So you have to understand the law and also the tech and stay on top of it, because it's such a rapidly developing field in both senses. Yes. So the specific use cases that's relevant to Crea 2 is, what I was doing is I was evaluating and processing materials for the dataset. And what we discovered quite quickly is the quality of this really needs to be properly assessed. And so what this means is that you have to analyze the text that goes into the datasets in order to make sure it isn't confusing for the language model, and also making sure that it's simply correct, and also scoured of potential privacy issues. And part of the reason of why it is important to have manual processing is part of this is what's called the curse of recursion. That's a very recent research article that came out, and it's essentially what this means is that by relying too much on the scraping on the internet for information for these large language models, you do end up with a decrease in quality. This is something that's been reported, especially for ChatGPT, over the last year. The quality in general has been decreasing. And in large part, that seems to be the fact that there is so much AI-generated text out there now that it becomes a recursive loop, which ultimately confuses the AI itself. Because even though the text looks very normal to us, the AI kind of acknowledges as its own. It's almost like a sort of inbreeding depression for the AI. And so therefore, especially for legal cases, like we need manual processing of these data sets. So yeah, so that it isn't just relying on itself over and over and over again, because it doesn't work. Let's see. And you also see some of this in the EU legislation that is coming out now, the AI Act really is focusing on ownership and how you handle the data sets more so than the models. And there's good reasons for this. Google itself has a massive documentation on how to evaluate the quality of data set. And the most important part here is this little quote. It's garbage in, garbage out. And so that is exactly what we should avoid. And that is, again, why it's so important to evaluate this manually and ensure true quality. But beyond just the quality as well, the importance of data sets is also, you can see that from OpenAI, people who work there, because there is a person who has been working there and has trained a lot of generative models. And the text that I have highlighted here is that essentially what this means is that if you have a good language model, when most of the language models these days are becoming quite good, but the most jealously guarded treasure of OpenAI has been their data set. It's been very well developed and is very secret. But ultimately, if you have a good data set and you can kind of put it into most functionally efficient and good language models and get kind of the same result. So really, the data sets in themselves tend to be the most valuable asset of all of these companies. So that's why that's so important as well. And another issue can also be ensuring that the data sets are free of privacy constraints. So this is another example of a research article where they found that you can actually reconstruct these data sets, these valuable things, by semi-malicious means, which means that if you can lift out the information that has been fed into the project, even though you don't necessarily normally have access to it, it really does mean that personal data and such, due to GDPR reasoning, must be something that you have in mind as you're developing the model. And yeah, you can know, yeah, that is essentially more of what I was saying. So in future or the next stage of the Crea2 project, I think we will also see that specific legal skill sets are needed. As we still need legal professionals to see whether or not the output we do get, because we can theorize and we can hope and we can make as much good models as we can on the technical side, but we still need people to actually see if it is usable and make sure that the way we are using it is also correct. So yeah, I've been rushing through because everyone's been going so far. In summary, I think we do need to be cognizant of not just limitations of use, but also the continuous monitoring of the industry and what is happening in general within especially such a rapidly developing area. One example here is this LLMattacks.org, which is quite interesting. It came out last year. What essentially they found is that you can generate jailbreaking codes essentially on your local language models and then apply that to large language models that are publicly available to jailbreak them, which is essentially disabling all the safeguards. And what that means in practice is that yeah, you could essentially, despite what other internal mechanisms you have in the language models that kind of attempts to prevent you from doing the various things, you can kind of get around them. And the most important part of that is these attacks are transferable. And so it seems like it's possible that it's an inherent flaw in large language models that may be exploited basically indefinitely until we come up with a better technology. So that yeah, that is something you need to be on top of and think about as far as during the development process, that you don't get into just thinking about the potential, but also about the risks and how you can mitigate that in case something does go wrong. And this is also true for how the legislation and realities change as we go along as well. You really do need to take into account all kinds of different things as we go along. And you can only do that with people, really. The AI itself can't really analyze reality as such, because it's not really there. And this ultimately, I think, can, as I said, give a good alternative to the status quo. But we need to make sure that the people who are doing this are well trained, that they do understand both the risks and the potentials, and ultimately, try to benefit society as a whole as much as possible without creating too many risks, but also without being too restrictive in your creativity, essentially. So my message ultimately is that yes, sharks are cool, and lawyers are known to be seen as predatory sharks, but that might be quite intimidating. Whereas whales, on the other hand, are quite friendly, and they, especially the filter feeders, they feed on krill instead. So going for more small targets rather than big juicy ones, I think is going to be the way forward for a lot of companies. But we should also be wary of threats such as Norwegians with harpoons. So something to keep in mind as we go along. So yes, thank you very much.
Thank you so much, Thomas. And let me introduce the last speaker of this session. So we have Dasha Tikar, and she joined recently our team. She's from the Slovenian team, Ljubljana University. She works also at the Court of Justice, and then she joined our team. Please, and be patient, is the last, but not the least.
Hello, yes, thank you for the introduction and for the invitation to speak, of course. As mentioned, I'm part of the Slovenian team of CREA2 and also SCAN2 projects. And I am a lawyer, so we heard very interesting perspectives and presentations on the projects also from the IT support and our team. And I am speaking from a perspective of a researcher, of a lawyer researcher. So what I actually wanted to present to you is some sort of challenges that the researchers can expect when collecting data. I will talk specifically about case law, because in CREA2 project, we were expected to provide the algorithm with some case law and also some legislation. But specifically when collecting case law is where our team encountered most of our issues. And also I wish to present to you the impact of national systems on data collection and national attitude towards data transparency. So as mentioned, we were expected to provide the case law for the CREA2 project. And my problem was that as I was supposed to search for the case law, we do not have the decisions of first instance courts digitalized. So it's not only that there isn't a database publicly accessible, there isn't even an internal database. So everything is still in paper files, and you need to request the court to give you access to these files, which is then a little bit arbitrary if it's allowed or not. And even if you get access to files, which I eventually got, the files are very thick. You need to search through the whole case file, not just the decision. So we do have a problem with digitalizations, as there is not even an internal database that will be digitalized and therefore accessible for researchers. I wanted to demonstrate here, this is our official case law portal, and we can see that the only cases you can search through are the Supreme Courts and higher instance courts. So there isn't the first instance courts database that would be publicly accessible, not even payable. And as far as we learned, most of the other participating countries did have at least some sort of a payable database that they could use when searching through case law. So I wanted to maybe give you a little bit of a background, what actually is the role of the case law in Slovenia. And even though the Supreme Court claims it's not a formal source of law, the practitioners do claim that it's the #1 source that they do use in practice. So it is very important. It is referred to in the judgments and also in the forms that are sent to the court, and it is used in practice. So it's an issue that practitioners cannot access this case law, and especially also as researchers, we also have constraints when accessing this case law. Additional very relevant question would be, are not court decisions actually public information? Because at least based on the Public Information Access Act in Slovenia, and of course, considering also the European perspective on public information and advocating for transparency, the decisions of the court should, of course, be a public information. And in that regard, we do have a free access principle, which means that everybody can ask to view public information. However, there is an issue in practice, since you need to request the court for the operating number of the decision, and you do not know the operating number of the decision of first instance courts. Even if the decision is referred to in, for example, public second instance court decisions that, as I explained before, are made public, the numbers are usually anonymized. Therefore, you cannot really ask for the permission to see the public information that a decision of a court should be through this request, as you do not have actually an operating number that you can request it from. So this is maybe an additional, a problem, as this should be a public information, but in practice, it's not really a public information. Maybe to simulate a little bit of our process. So we do have a Courts Act that allows the president of the court to decide if he will allow the access to court archives and files or not. But this is completely on the president of the court to decide. And even so, my process was to, at the beginning, request the presidents of the court to give us the access as the researchers, which of course, as GDPR and personal data national legislations allows researchers to search through files. It is still up to the president court to give the access to the files or not. We were lucky to get that access at the end, but it took 2 months. And once we got that access, we were just presented the physical files and not any sort of digitalized files. So even the process of data collection was absolutely not in a digitalized form, as we need to search through all of the case files physically. Additionally, we wanted to collect the data from the notaries, and there is also a Notariate Act, which was not in our favor, as the board of the notaries declined our request to get the access, because they said that not only should the notaries keep the personal information private, but all of the information about the deeds that they draft. So we were declined that request, and we did not at the end get the access to notary deeds. So I also wanted to address a little bit of digitalization trends in Slovenia. And the positive trends should be that the Supreme Court does advocate for transparency, so the official decisions do advocate for transparency. However, in practice, this is not really the case, as it's commonly expressed that actually courts do not give access to the researchers even to search through their files. So we were quite lucky to get that access. Additional question would be, why is there not a digitalized form of first instance judgments? And unofficial answer from the ex-Minister of Justice is that it's actually just an administrative issue. So there isn't any legal background that would state that the first instance judgments are not digitalized, but there was just an administrative issue. Slovenia is sort of a small and a young country, so there just isn't enough stuff. And of course, as explained before, we were collecting data on cases where there was a division of property and there in inheritance and divorce cases, and there's a lot of sensitive personal data in this sort of cases. So we were actually lucky to get access even to that data, and then the researcher still needs to keep the information, of course, private. Additional very negative trend is that there was a proposal of a new Courts Act in actually a couple of months ago. And this was very much controversial in practice, because this new Courts Act stated that the decisions of the court should not be even considered a public information, and that the decisions of the court should only be published if the judge that decided in the case actually also suggested for the decision to be published, which means that in practice this would be a major problem, as also the second instance judgments would not be automatically published, but only if the judge suggested for the Supreme Court to publish these decisions. We do not know how this will go through the parliament, but there were a lot of negative feedbacks on this proposal because, of course, it's very hard to practitioners to work if they do not have access even to, for example, second instance judgments. So I would also maybe like to express a little bit of data protection implications. So of course, as I already mentioned through my presentation, there are a lot of personal data that should be protected when dealing with such judgments. And yes, as mentioned, there even when digitalizing such decisions, everything needs to be very anonymized. It's a major administrative process. And another unofficial information is that there is a company that got the commission to do this sort of digitalization process. However, this was not yet done, and we do not know when it will be done, but there should be some sort of process in the process. Yes, and as I already mentioned, the big problem is that there isn't even an internal database of the courts. So basically, each judge only has, let's say, their own computer and their judgment on their computer, but they do not even have, for example, first instance judgments in one sort of database. So how should there be a process of digitalization if even the internal systems do not digitalize this sort of information? Yes, so maybe this was, I wanted to demonstrate to you the issues that maybe a research team, a legal research team can encounter while collecting sort of data that of course needs to be provided for the AI algorithms to be used in practice. Because without this sort of information, of course, the algorithms cannot form any sort of answers. And I think that our case clearly demonstrates what is the impact still of the national culture and the national legislation on data accessibility. Of course, there is a lot of personal database that needs to be handled very carefully. However, this is not an excuse for the digitalization not to take place in practice. Otherwise, we cannot, not even researchers can work, we cannot develop anything. So this is, of course, a major issue. And for the end, maybe I would also like to express that these are, of course, not the only issues that the research team can encounter in practice. I just wanted to focus on data collection process. But for example, another issue is that we wanted to translate everything, and then it's a little bit, for example, Slovenian language and other languages from national teams are not very common. Therefore, there are additional issues with translation and this sort of aspects. However, this can be dealt with. If we do not have access to that data, this is a little bit of a very negative perspective on the development of such algorithms. So thank you for your attention. I wanted to express this and yeah, maybe to give you a little bit of a different perspective, since we talked about a lot of positive trends. Also, maybe a little bit of where can we continue. Thank you.
Thank you, Dasha, and thank you all. Like, if you have like one or two questions, or
yes, you can ask question. Obviously, you are all encouraged to ask question. After only one or two questions, there will be a coffee time.
everyone wants the coffee, suppose.
Everyone
Okay.
wants coffee. So please take your questions to the coffee break. You can ask the panelists directly. Thank you very much and see you soon. Yes. Okay. Really perfect.
Thank you very much. No. Flavia, back to you.
And as for email, or put it here with
I'm
the
looking for
icon.
which and
All right.
we are now full of energy to continue the second panel. So now I'm giving back the floor to Marco Giacalone to introduce the speakers for the remaining part of the second panel.
Thank you. Okay, so here we are again. We keep going with the presentation regarding the CREA2 project. So now let me introduce Ivana Kanceliak. She's part of our Croatian partners, University of Zagreb. Ivana is a lawyer and a postdoc researcher at the University of Zagreb. She works in notary offices, and since 2016, she discussed her thesis, and she's still working with the team since then. Thank you, Ivana.
Ladies and gentlemen, dear colleagues, thank you for your kind introduction. First of all, I would like to thank for giving the opportunity to present here today. And also I would like to thank to organizers for organizing this event. So my presentation is inspired by CREA2. And in fact, it is based on a hypothesis that one day, maybe artificial intelligence could dissolve co-ownership in special procedures. So when it comes to regulation of dissolution of co-ownership in Croatia, we can see that there are several norms that regulate dissolution of co-ownership. So we have Property Act, and also if there is consent between parties, we can use Non-Litigation Procedure Act. So we can go to public notary and dissolve co-ownership. Also, when consent doesn't exist, we have to go through civil procedure. So my main thought is that if we want to create and use artificial intelligence to dissolve co-ownership, would it be enough to teach her only those norms that are assumed to be the legal base for the solution of co-ownership? So my main hypothesis and my main concern is that those norms that are listed on this presentation just won't be enough. So I want to show you what could be problematic. So when it comes to collaboration between artificial intelligence and land register, in Croatia, we still have a lot of problems with land register. And in many cases, we can see that information provided by land register is often incorrect. So the first thing that a judge has to do, or a public notary, is to check the data provided from land register to see if the solution is even possible, to see if parties are co-owners. So my concern is that sometimes when in land registry, you don't have a specific or correct situation, you need to have two claims. First, you will go through determination of ownership, and then you can dissolve co-ownership. So my concern is that it means that artificial intelligence would have to know everything about acquisition of ownership in Croatian law. Also, when it comes to geometric division of property, so when you have to divide one part of land in small pieces, you need an expert. So I'm not sure if artificial intelligence can do it by herself or by itself, or is it even possible to engage experts directly by artificial intelligence? The other thing is that we often see in court decisions is that sometimes co-owners say, okay, I have invested in this property, and this means that my co-ownership part has now increased. It's a problem. In Croatia, investment doesn't mean that co-ownership part is increased. So what I want to say is that artificial intelligence should know that we have this specific regulation. What co-owners can do, they can only use claim based on unjust enrichment. And the third thing that I found by reading the judgment and preparing for chatbot for CREA 2 is the fact that in 2 cases, we do not have a lot of cases. In 2 cases, we had parties in appeal procedure, and they said, I have a right to home. After they received the judgment, they became aware that after public sale will be finalized, they will lose their home. So in a way, it seems that we have a collision between right to dissolve ownership and right to home, which is based not only on European Convention, but also on Croatian Constitution. So in that case, it's questionable if the judge should have said something during the procedure. Maybe he should warned parties in procedure, because in those cases we had one woman, she was 80 years old and she had to leave her house. And in another case, we had a woman with 2 minor children. So they became aware of this public sale after the judgment was enacted. So it is a problem with the proportionality test. Would artificial intelligence be aware to warn the parties? And should it maybe be made ex officio, not only by artificial intelligence, but maybe by judges? I usually don't have long speeches. So I just wanted to conclude that using artificial intelligence as a tool for dissolution of property, co-ownership of property, might be included with some problems. The first one is, of course, land register. And the other one is the problem with engagement of some experts. How to overcome this problem? So in Croatia last year we have a new regulation that regulates mediation, obligatory mediation. So when it comes to tort law and damages, mediation is obligatory. So maybe it is possible to create another rule that if we do not have consent between parties who want to dissolve co-ownership, it is possible to organize obligatory mediation. So mediators could use artificial intelligence as a tool. So they could check land register, they could engage experts. And the other thing that I was talking about as an alternative to the solution of co-ownership, I was thinking to create an alternative to the solution for the creation of special right to time limited use. It is actually the base of timeshare or time sharing model. Okay, that would be all from me. Thank you for your attention.
Thank you so much, Ivana. And now let me introduce our colleague, Milda Markevičiūtė from Lithuania. She is a lawyer working at the Cobalt law firm as a managing associate, and she also discussed her PhD, and she is part of Vilnius University as a postdoc researcher, and her main focus is on e-justice and alternative dispute resolution.
Good afternoon, and thank you for having me. My aim today is to review what we learned from digitalization and what principles can we apply in further steps in going into automation of justice. And one might wonder why my topic sounds so unrevealing and mysterious. So I have to be honest and say that I came up with a topic around the Christmas time, and I'm not sure how it's about in your countries, but in my country, there's 2 ultimate Christmas movies, and that's Home Alone and Harry Potter. And so here we have it. Harry Potter is going to help me to introduce some principles from digitalization that I would like to bear for us in mind during the next step. And of course, the disclaimer here, pictures are Googled, I own nothing, everything belongs to whom it belongs. So let's go through it. So although our everyday lives have been transformed by the internet and by the power that we have with us in our pockets, in our phones and in our laptops, when we talk about justice, we usually have the same image in our heads, despite all our talking about, artificial intelligence and digitizing justice and various tools, we still have similar image being people with special attire giving eloquent speeches in spacious, splendid rooms like this one. But many challenges of automation and of digitalization comes with the experiences in this justice. So one important step that I would like us to have in mind, that if we do not have proper digitalization, then automation is not going to be effective. So you can create whatever systems you like, and you can create whatever tools you like to divide whatever assets you can think of. It's not going to work, and if people would not use it, then it would slowly decay and be forgotten. Because digitizing justice is a struggle. Let's not be naive about that. Funnily enough, my country, Lithuania, although being a small country, has had very good experience with digitizing justice. So some lessons that we learn, I think, can be applied for us here. Unfortunately, that does not work on glass. So first, when we talk about digitizing justice or automation of justice, attorneys, lawyers, usually tend to focus on the part that allowed them the flexibility, meaning e-filing and court public database, and being able to receive court orders in their phones and something like that. But the thing that lawyers from law firms usually forget, and I think we should not, is another part, the court's perspective, meaning that equal importance of digitalization and automation should be given at first at what court has to handle. So meaning that automation of procedural decisions, creating convenient templates, gathering statistics, internal databases, etc., etc. If one focuses on e-filing and fancy external tools and does not enable courts to handle it properly with proper software, software that's always updated, constantly updated and invested into, with proper hardware, then such automation may be destined to be used in limited capacity or slowly die. And believe me, we tried to create some tools that were very effective for lawyers and that had to be shut down temporarily for 4 years now, because the court's internal hardware could not handle these tools and these amounts of data analysis that external lawyers wanted and created actually systems for it. So Lithuania created and launched our internal court system back in 2004, 2005. It wasn't until 2013 when we introduced external additional functionalities, like external portal, which communicates with internal portal. So the users, the parties to the dispute, or the lawyers, files the documents in the external portal, which goes into internal court system, and vice versa, without using emails or some other means of communication. So statistically, let's see if I have my statistic here. Yes. Statistically, over 86% of all the cases that we have now in Lithuania are handled electronically only, meaning there's no paper file, no one sends the paper, no one receives the paper, with very rare exceptions, and now sometimes even not go to court physically. Out of these 86%, we have 43% that are automated court orders. It's a simplified procedure using a special template with fields of metadata, which allows the court, if things in the document is properly written, to generate court order with a few keys and a few buttons. So over 43,000 court hearings per year are handled via teleconference or via Zoom. First it was conference, and the pandemic taught us to use Zoom. And the numbers, they do look pretty good. So let's have a closer look how we did it. And here I mean not the tools and technical nuances, I mean the principles that made the people to accept the changes and use it in their lives. So now one thing to prepare oneself. Oh, this is the statistics about the actual court hearings. I forgot to change that. So going further, one thing to prepare yourself when going to digitalization and automation is that no matter how good the system is, it is going to be an uphill climb because it requires the people to do what the people like the least. It is to change the way we think and change the way we work. So it so happened that I have a story, and my colleagues from CREAP and SCAN projects have already heard it, so I'm sorry for being repetitive. I was involved in a working group that designed our external court system, allowing lawyers to e-file documents. And consequently, I was the point person in my law offices responsible to teaching other colleagues how to use it and promoting it. So like for a year or so, I used to receive phone calls shouting at me and saying, what the have you created with a system? I'm not going to use it. I want to do the things the normal way. And mind you, not the old way, the normal way. That is printing the boxes of documents and sending them via post and eventually making forest cry. So after about a year, I started receiving different phone calls whenever anything went wrong. And it was like a new line was, your system, apparently it's my system, but your system does not work. Do you expect me to print the documents and go to the post office in the middle of the night like a moron? What's the right answer to that? Yes. So it took about a year. It shows that any novelty will face resistance. So you have to push through. And in order to push through, you have to create some kind of a carrot that you can use. So not only the stick, but also the motivation. So what did Lithuania did? We introduced a clause into the Civil Procedure Code, making for lawyers and big litigation firms and companies like insurances and state-owned companies mandatory to receive documents via the portal. The idea being, if you have to use it for receiving documents, one day you will use it for filing documents. So if we look once again into the statistics, we have about, in 2002, we had about 3,000 attorneys and assistant attorneys at law using the system. And next to that, we have overall, we had 126,000 users, individual users, meaning that if we subtract the lawyers, we still have more than 100,000 external users that are natural persons and companies. And here, mind you, that we're a nation of less than 3 million people, so 100,000 users in courts, it's a lot for us. Another thing that Lithuania did, how we used the carrot, is that we decided to that discounts works and sales works and Black Fridays works. So when filing a claim, we have to file and pay a stamp duty, which can reach up to 22,000 euros in respect to inflation. And we introduced a discount of 25% if you file documents online. So it's one thing if you want to stick to your guns and stick to your old habits. It's another thing when you have to explain for your client why it has to pay 5,000 or 6,000 euros more just because its lawyer does not want to use the technology. So we evaluate and we think that this was also very one of the things that made the portal and digitalization a success. Another thing and another problem that is quite important, and we saw that especially before the pandemic, it's user-friendliness or user-centricity of the system. So again, an old truth, but an important truth, in order for the system to be used, it has to be user-centric and user-friendly. We have a document management system at my law offices. I saw that, I said that it was not practical. I was told by administrative staff that I'll get used to it. Guess what? So the same is here. And then our courts understood that the lawyers can file documents from vacation and via phones. Then actually judges became a little bit irritated because they did not have the same flexibility to access the court systems. They were told by the administrative staff that it's impossible because of security protocols, data protection, etc., etc. And then March 2020 came, and then the quarantine was applied. And then for the first week, all the hearings was postponed. And so for a second, and the third week, everybody tried to raise the question what to do now. Because you can postpone the hearings, but you have to draft a decision to postpone the hearing, and the decision has to be drafted and uploaded into the internal court system, which cannot be accessed from home, and the judges cannot leave home because it's quarantine. So it took additional 3 weeks for administration to solve all the list of problems that we found before. All the security protocols and firewalls and etc. was solved in 3 weeks, which was impossible a year ago. It took additional 3 weeks to buy professional Zoom licenses. And now we have courts and judges that do not do live court hearings, except for very, very extraordinary cases that prefer it to be handled via Zoom. We have also judges who prefer live hearings, so probably that depends on a person. So what I wanted to say that after you have a functioning electronic system, then you can focus on automation, which then in return would serve as a tool for you. For automation, the same principles as for digitalization applies. However, if it is decided to use additionally artificial intelligence and other tools, one must not forget to follow additional principles promulgated by the European Council and like respect of fundamental rights and not discriminatory, and equality, security, transparency, and also the principle of under-user control. For example, we heard today about Scan2 and Gria2 about tools, how to automate things, to divide assets. So such tools could be integrated into the internal systems to be used in the efficient manners. Of course, they should be under supervision of professionals, for example, Supreme Court judges or consultants, legal consultants in the courts, and it would also add to forming new court practice and new case law. So my general idea to leave you with is that it is very much okay to want to buy flowers for your living room, but you might as well clean the house. So thank you for your attention, and I hope to discuss it with you more.
Thank you so much, Milda. And let me introduce the last speaker of this small panel, is Tina Hoffman. She got a PhD at the University of Tartu and at the Institut National des Langues et Civilisations Orientales in Paris. And she's an expert legal and technical translation. She discussed a thesis on audiovisual translation history and semiotics. And now she's also a coach about machine translation and AI. Thank you, Tina.
Yeah. Hello, everyone. It's a pleasure to meet you all in person, not via Zoom meeting. And very heartfelt thanks to Marco Giacolona and Paola for guiding me through the whole process here, being part of the team in creating Crea2 chatbot legal database text translations. My background is that I'm legal translator myself, and sworn from the French language. And usually I would, for foreign translations, I would never dare to use machine translation in any cases because of the hazard of personal data leakage. This time, I had this daunting task of creating machine translation, generating machine translations for the court cases that had an extremely high volume and very tight deadline. And the task was to train the chatbot like Matthias was explaining before. So we had to be able to create quality data sets for this task. Estonian team was composed of 3 people. First, Karina was presenting yesterday. She was searching the databases with keywords. Estonian language is a little bit tricky because we have 2 types of infinitive and case endings in nouns, but everything is digitalized, meaning that actually she could find easily 10 to 20 court cases per week. I think the time that she spent was approximately 20 to 30 minutes to do this. So it's significantly less than the Slovenian and maybe other countries are experiencing when finding the source text. Then we had to determine the high relevance of the input, meaning that some court cases were nevertheless not really relevant, and we skipped them from the data set. Estonian court cases were already anonymized, but before feeding them to the machines, we had to delete. Nevertheless, there were some names inside, like names of the legal representatives, etc. And we had to bear in mind that we were working under time constraints, so it wasn't really possible to apply the traditional translation methods when you compare source text to the target, like segment to segment, sentence to sentence. Basically, my task was to guarantee that I went through the target only, not comparing with the source. So I think it was, and it's still relevant to combine the traditional working methods with AI-backed MT solutions. Traditional, there I mean creating translation memories and using glossaries and something that translators call computer atomized translation tools. We use Strada Studio because it has OCR built in, and for PDFs it was quite useful to have a high quality OCR, but there are other CAT tools that can be used instead. And those CAT tools are able to integrate DeepL and Google Translate APIs that will provide the machine translation for the whole document batches. In minutes, let's say, you can process like 200,000 word batch within 15 minutes. The target output was then manually corrected in Word formats. And that was, this last task was done by Thomas Henriksson, and this was our team, like three people working on it. If you want, if you're interested, there are step-by-step batch tasks that can be maybe useful for Slovenian and Croatian teams. If you are interested, I can provide you with some tips how to do it. The main trick was to process all documentation all together. It will guarantee the best coherence. So I used Strada Studio, then running, first of all, running the translation memory, and already 1/3 of the batch was usually translated because it came from the previous projects. Okay, the first batch was then the pilot one. That wasn't really the top-notch quality, but after that we improved with each batch. And then I confirmed everything that was 100% accurate and some high fuzzy matches that were like partially overlapping with the previous translations. And then I ran on the whole batch to machine translation. That literally is the speed of light. It is really the fastest way to do it. And after that, not reading everything, like the whole target, but first the quality control to ease the task. And this can be either automatic or manual. Better to combine them both. Automatic would be verifying that the glossary is applied, and I needed the glossary ready before because the names of the Estonian legal acts were usually wrong by the machine, and the legal terms were also quite incoherent. Then I made sure that no split segments or confused semantic info went into the target, and all numbers are correct. That is quite tricky with referring to some legal act paragraphs, because there is a set of numbers going to some subpoints, and in Estonian referencing system, it's already confusing to put it into English format. There is some like manual correction to be done, but it is easy to find the errors with automatic QA or quality control. And then there are like batch tasks where you can filter out all the suspicious abbreviations or special signs or some characters and correct them all at once in all the documents. After that, I needed to just confirm all the segments and update the translation memory. It would mean that next time it is next time it is fully accurate and can be applied to another batch. Then manual check of the layout and still making sure that the text is anonymized. Now the promise of the AI-backed MT. I would say it is considerably, it's getting better and better every year, and I'm not sure if I would be talking the same, making the same presentation next year, because it's changing like within months, and I cannot say if in weeks, but within months. The quality is changing all the time, and it's usually getting better. The AI moment, the generative AI moment, is actually not really used in this process, except when you use DeepL in certain computer optimized translation tools, like Phrase, for instance. There you can have the benefits of the generative AI, but usually it demands very special skills, and you can train the AI just by going segment after segment and confirming and training the AI's memory, and then afterwards the empty output that is proposed is already considering the changes that were made before. But as I said, it's only a small percentage of the whole process. It still demands a lot of traditional methods, and those traditional methods are also computer optimized. Nowadays, it's not on paper, so it's developing really fast. But where you can really use AI is making sure that the machine translation output has no problems. You can ask the AI to find errors in the target text, like Mr. Kowalski was telling yesterday in the ChatGPT presentation, so that the targets in Word actually can be thrown to the AI generator and asked specific questions. Is it fully anonymized? Are there any semantic issues, etc.? This method we didn't really use, but it's an option to try it out. Generative AI can be also used to detect spelling mistakes that for the Estonian language is usually the problem with the machine translation. If you translate into Estonian, but we translate it into English. Here is the comparison of two CAT tools that can be useful for lawyers. One is Trados Studio that we used, and the other is Phrase. The Phrase is a cloud-based and generative AI-backed system where you can incorporate DeepL or Google Translate API. But the problem of Google Translate is that it is leaking personal data, and it has also a disclaimer about it. So be really cautious before feeding anything into Google, because they will divulge everything. And they are publicly saying this. But with DeepL, it's a Germany-based company, and they promise their DeepL Pro version for legal teams that is fully tight regarding the data leakage. I don't know if it's true, but that's what they claim. To end with the problems that the machine translation and even AI-backed machine translation always will have is that it relies upon human-made translations that are not fully reliable either. So the usual score for human-made translation is, if you rate it from 1 to 5, something between 4 and 5. So the machine translation departs from this corpus and is repopulating, regenerating the human-made mistakes that is very often translating a meaning from negation to affirmation, or mixing up or even forgetting some parts of the source text. That is especially annoying, because when you read only the target and there is a part of the source that is left out, it is not good. And there are some means to determine these kind of mistakes, but it's tricky. The problem remains also with the usually smaller languages like Estonian, or I suppose Slovenian, Latvian, Croatian, because of their already the text corpus is smaller to rely upon, but the machine translation also has many problems of following, for instance, Estonian punctuation rules, getting through our abbreviations, names, cases, and gender. For instance, if we want to translate Estonian text into English, we don't have, the source text has no gender, but in English we are forced, the machine is forced to choose either he or she. And we also don't have, for instance, a verb for the future, and it is coming out from the context if we mean the present or the future. But there again, the machine will automatically guess, but guessing is not really reliable all the time. Source text formatting and spelling mistakes are also very often, even with the Estonian court cases. I noticed a lot of typos that were confusing the machine to the great extent, actually. There were also in this is a raw input. The title, kohtuotsus, or court decision, has space between each capital letter, and this for DeepL it was already problematic. Then you can see that the problem also is even to translate the civil case was translated like civil glass. I don't know why. And such a lot of source mistakes, not source, but target mistakes that are easy to correct in bilingual view, easy to notice if you have glossaries and quality control means, but just to like manually correct everything in target word files is tricky. And here is another example of the semantics that is completely confused because of the anonymization of the data. Who does what? It is problem for the machine to understand. But we can overcome all those like they are rather small problems because I would say like this state of the art that we have now with machine translation has the potential to speed up translators' work maybe even 90%. So it is really boosting up our productivity. It's getting, we can offer lower prices for the end clients. And I would even say the lawyers can do the work their own if they have time or resource and the necessary skill sets to do this. They don't even need to rely upon translator because they know their own texts. They are the specialists. So the translators can help them out, but it is nowadays that everyone can be a translator, and the translators who and translators also will not be deprived of their work unless they refuse to use the AI-backed machine translations. I guess this also applies for lawyers. The ones who are refusing to use those new tools will have a hard time of being competitive on the market. So thank you very much. And if you have questions, please.
Thank you so much, Tina. And
Yes.
let me going to ask a couple of questions to our speakers.
Thank you. Thank you very much for your presentations to all of you. Well, we are a part of the same consortium, but I really know the difficulties that we encountered with language or by the automatization that you relied before. And so I really know the problems that we need to focus our attention on. But do you have some, since you made such a good presentation of the problems and the facts that you're dealing with, I know the time was not that long, but imagine if you had now more time. Do you have any tips or suggestions for all of us to improve such problems with translation or the automatization? Because I really know that, just to inform the public, that we encountered problems for the creation of this database because it is very hard not only to translate, but also to anonymize the proceedings. She really explained us that they did this work manually and digitally. So let's try to really focus our attention on how it can be done in a faster way, because this is really the hardest thing.
You can really do it faster when you have this software that can combine all the files into one, and then you can ensure the quality control and coherence between the files, the glossary or the terminology is adequate. And after finishing one batch, it is essential to create a translation memory. And after the first batch, you will have a very quite reliable, okay, you can always make improvements, but quite reliable translation memory that you can apply from even beginning any other tasks to your new patch, you apply it, you have 1/3 or 20% translated, and you reduce the volume significantly. And the translation memory will go bigger and bigger, and it will go faster and faster in the end. So you can really boost up, like with every new patch, you can be a little bit more competent, a little bit more faster, and have a better target and more qualitative data set in the end.
Thank you.
Thank you.
Any other question? But in this case, thank you so much, and another round of applause for our panelists.
Thank you very much. There will be no break between this panel and the next one. I will be moderating the next panel. It will be devoted to the AI Act. I would like to invite to me Francesco Spina, who will be the first speaker. Yeah, so please just let me share with you the idea behind this specific panel. Now in the European Union, we are facing the final stage of drafting Artificial Intelligence Act. So last month, European Union entities, Parliament, European Commission and Council reached the political agreement about the text of Artificial Intelligence Act. For now, we do not know the final version of the regulation, but we assume that in upcoming days or weeks, we will be able to get familiar with the whole planned regulation. Now I'm giving the floor to Francesco. Would you like to stay there or do you want to go here? Yeah, so I invite Francesco here. Let me introduce Francesco to you. Francesco is an Italian attorney, a criminal attorney. He's also a member of the FBI New Technology Commission, having a great experience in digitalizing legal sphere, but also the use of AI. And today, the topic of his presentation is so difficult that I don't even try to to say it, but he will combine very broad, even philosophical perspective of the use of AI and AI Act itself. So clap our hands from Francesco.
Thank you, Maria. Thank you, everyone. But I have to contradict you. It's not difficult, it's just weird. It's a very weird title. Does not mean it is difficult at all. Hopefully, by the end of my speech, it's not a presentation. I don't have slides, I don't have a presentation. It'll make a little bit more sense. I just would like to share with you a few thoughts, maybe broader thoughts about these topics. So I will mention the AI Act, but I will not delve into the specifics of the AI Act. I believe that my fellow speaker, Alexandra, will delve maybe a little bit more about into the specifics of that in a little while. So what does a criminal defense attorney from a small town in Tuscany have to say about this? Well, I'm not a PhD. I'm not an IT expert, so I'm used to stand in court. That's why I'm speaking to you from here and not from there, because I'm used to stand while I discuss, while I ask questions to witnesses, while I try and defend my clients. There was an interview a few days ago on the Italian radio from a colleague of mine that came to my mind when I read the subheading of this panel. Well, it's not shown here, but you have in your agenda, and that made me wonder what kind of mindset lawyers, jurists in general, lawyers in particular, should adopt while facing these topics and the issues brought by AI. Because how to use a tool is not, and I'm not using the word tool by chance, is not such an easy matter. So I believe that in discussing the AI Act as all the regulations, we have also to discuss broader questions. I was mentioning at this interview that I heard a few days ago, where Luca Bolognini, a colleague of mine, he's head of the Italian Institute for Privacy, not to be confused with the Garante that you might have heard last year. The Italian Garante had something to do with ChatGPT, but that is a private, the Garante is a public figure. This one is a private institution. He said something like, we write laws as we look at the stars. So what did he mean by that? When we look at the stars, we have the impression that we look very far from where we are. Instead, we are looking at the past. We're looking from light, a light that comes from a very distant place and a very distant time. And that reminded me a little bit of the regulation, of course, and the activity that jurists do when they write laws, as Luca was mentioning, and even the AI Act, maybe. Law always follows societal changes, and especially the ones derived from technological changes that happen at a very, very fast pace. If you think of not AI, let's say Kodak. You all remember Kodak Company. Kodak Company was founded in 1888. Think how fast it was to file Chapter 11 for bankruptcy in 2012. After the the presentation of digital cameras, and especially smartphone with digital cameras. It's not over, but Kodak had to face major reorganization after almost more than 120 years of history. AI is even faster than this, is even more disruptive than these. My generation, I'm from 1980, I was born in 1980, has seen the revolution of communication, not digitalization in general, but communication, specifically the internet. That was our revolution, and that was fast. This is way, way faster. So how can we hope to regulate such a slippery field? When we started working with the FB New Technology Commission on the AI Act, it was, I believe, September 2021 during the Paris Congress, and we only had the draft of the AI Act. We didn't even have a full proposal. Now we have a proposal after the whole trilogue phase, and we hope it will become effective. But even if it does, it'll take 24 months, so it won't be effective until 2026, because it takes 24 months. And even when it becomes effective, it'll take even more time. Specifically, sorry, I have to read this, I don't remember by heart. It'll take 6 months after entry into force. Member states, this is the term that member states shall phase out, the term the member states have to phase out prohibited systems. You know that AI Act works on a risk-based approach. States have 12 months, in 12 months, obligations for general purpose AI governance become applicable. In 24 months, after 2026, all rules of the AI Act become applicable, including obligation for high-risk systems defined in Annex 3 of the AI Act. In 36 months, obligation for high-risk systems defined in Annex 2. So it's quite a time. But we've seen how fast things change. When OpenAI was presented to the public was November 2022. And then we had the news that it gained a lot of, about 1 million users in 5 days, something like that. So what can we do? Are we destined to end up like the Italian Garante, for instance? I don't know if you remember, but March last year, news spread that the Italian Garante for Privacy stopped ChatGPT in Italy. That was not exactly the case, actually, because eventually it stopped ChatGPT, but in the beginning, OpenAI decided to stop, to prevent Italian users which was of course completely useless since VPNs exist to access OpenAI from Italy, because the Garante raised some concerns about about data protection and the use that OpenAI was doing of data, especially data of minor. There was no safeguard preventing minors to input their data into the system. That was one of the main concerns. And then what happened? OpenAI blocked the access to ChatGPT in Italy for a while. And then after a few weeks, everything was exactly as before, except for some minor tweaks. But all the main concerns that were addressed by the Garante were not solved, are not solved as of now. But OpenAI, of course, had a very important free marketing present from the Italian Garante, because, of course, OpenAI could present itself as the company who was caring about all the concerns raised by public authorities. So are we destined like that? There is a fable from Jean de La Fontaine, The Coachman and the Fly, I believe it's translated in English, where a fly stings the coachman, and then the fly believes that he's making the stagecoach move, instead, of course, it's the coachman and the horses. I don't think that is the case. But before trying to answer that, we have to ask, why does artificial intelligence bother us so much? Because I have the impression that when we operate these tools, and again, I'm saying tools, because that's what Pavel, I don't see Pavel right now, said yesterday. There you are. We not forget these are tools. So why these tools trouble us so much? I have the impression, I was saying, that we treat them like some kind of oracle, like we're in the presence of an oracle. And maybe we are. But we have to understand, I see some of you are shaking their heads, but we have to understand what is an oracle. Because if we think of an oracle like something that can reveal all of the truth, well, that is not an oracle. That's why I mentioned I Ching in the title of my presentation. I don't know if any one of you is familiar with I Ching. It's the Chinese oracle that let's call it oracle, that's all usually accessed by throwing coins or sticks and then trying to interpret what the page of the I Ching says. I give you another example, a lighter one. Hitchhiker's Guide to the Galaxy. Does anyone know the novel or the movie? Well, in the novel and in the movie, it's a very funny novel from 1979, if I'm not mistaken. This civilization builds a supercomputer. Supercomputer, ChatGPT is nothing. And they feed this computer with all the knowledge, all the data, and then they ask the computer the final question. What is the meaning of life, universe, and everything? And the computer takes 7.5 million to think about it. And then it comes up with an answer, 42. And that word is quite pissed at the computer, because it said, let us understand, you took 7.5 million years to tell us that the answer is 42. And it replies something like, guys, yes, because that question does not make sense. You don't know what the question is, so I cannot provide you with an answer. So in that sense, yes, it is an oracle. But if we want to address the oracle, we have to worry about the questions, not about the answers. So why, as a criminal defense attorney, I'm forced to think like that? Because as I was saying, I'm used to ask questions to my witnesses. And I know that if I ask random questions, I'll probably have random or even dangerous answers. The name of the computer was Deep Thought in Hitchhiker's Guide to the Galaxy. And at the point where we are, what we have, and please, Pavel, correct me if this is wrong, are basically what is called a stochastic parrot. So, stochastic parrot, why? Because a parrot, what does a parrot do? It repeats what the parrot hears stochastically, let's say randomly. I know I'm putting things simply, but just to give you an idea. when we interrogate ChatGPT, we have an answer, as Paolo explained yesterday, that is made with some level of randomization from huge data sets that are that have been given to ChatGPT, and this is what we have. So, and we were discussing about this with Christian, I believe, before. When you start using ChatGPT, the first thing that you learn is that you have to learn how to ask the questions. And why I believe lawyers are in the perfect spot to ask these questions. Because lawyers, jurists in general, but lawyers in particular, are exactly in the right spot between ethics and epistemology. So epistemology implies to try and learn how a tool works, but not ending up there, because that is, in a Greek word, what's called techne. But epistemology derives knowledge from experience, let's say, to put it simply. On the other hand, we're used to worry about the rights of our clients. We used to worry about very concrete and troubling issues. And we do have, not only because every European country has an ethical code, it changes a little bit, but not that much. But we have built in a sense of ethics. Every lawyer has it. So I think this is the right spot to try and find the balance needed to ask the questions when we write laws, when we interpret laws, to apply the laws. And maybe, just maybe, if that is the case, the fact that it takes time for the law to adjust to societal changes, to technological changes, won't mean that we are useless, because we are not. This means that we will learn to use these tools in the right way to do our job. It'll change, yes, but we'll still be there. Thank you for your attention.
Thank you very much, Francesco. I need to admit that after your presentation, your speech, the title of the speech makes a little bit more sense. And I also enjoyed that what you said is a kind of a bridge between your approach and what even Pavel yesterday presented. The issue is in asking the right question. Now let me introduce you the second speaker, Aleksandra Kraśnicka. Aleksandra, please join us. Aleksandra is a Polish attorney at law specializing in cybersecurity and privacy protection. She's also a member of the New Technology and Digital Transformation Committee from Wrocław Bar Association of Attorneys at Law. And today, on behalf of herself and Anna Augustyn, who cannot be with us right now, will introduce the topic of the European path towards AI regulation. The floor is yours.
Thank you, Maria, for introducing me, and thank you for having me here. So I would like to start from explanations, because I'm here on behalf of myself and, as Maria mentioned, my colleague Anna, who is not feeling well. So I'll be just reading her presentation because she put a lot of effort in it, and it's worth to present it to you anyways. And also part of our presentation will be interactive. So I encourage you to scan. Is it working? Yes. Okay.
We are encountering some minor technical issues, but we will solve them. What should be the most important information right now after this presentation? I promise we'll go to the lunch break altogether. So we just need 2 more or 1 more minutes to finish the technical issues. Good.
Apologize, technical issues. So part of our presentation will be interactive. So I encourage you to scan a QR code to get the access to presentation. And based on that, you will be able to answer some of our questions that we will ask you during the presentation. And if you are not able to scan the code, I think you can enter these numbers. Yep. Yes. So, can machine think? This is a well-known question asked by Alan Turing 70 years ago, so it's kind of a symbol of the beginning of this AI journey. It is still current and valid question, but of course the topic in general is not new. We have 2024 now, but the first official AI conferences took place about 40 years ago in 1980 at Stanford University. Just 27 years ago, world chess champion Garry Kasparov lost the game with Deep Blue, a chess-playing computer developed by IBM. These are just a few small examples, but today, AI became an integral part of our daily lives and economy, and it is present not just in our professional legal work, but almost every aspect of our lives. It's in industry, medicine, art, education. It analyzes our data, our face to unlock the phone. Many people wonder if this is the right time for regulatory action. Some argue that AI should stay unregulated. Others believe that this is the best moment for the European Union to take the lead with AI. Some people think it's already too late and that law will be always a step behind technology. But we have plenty of examples where the lack of regulation is dangerous. AI can provide incredible development, but it also can be profoundly dangerous. This shows how much we need to regulate these issues. The AI Act isn't the first of this kind. The white paper on artificial intelligence released by the European Commission in February 2020 outlines a framework for trustworthy AI development and deployment across the European Union. More importantly, we have also GDPR, which is not directly about AI, but it is largely connected to data protection issues. Nearly 3 in 4 lawyers, 73%, say that they plan to utilize generative AI in their legal work within the next year. So we would like to ask you a question if you already use AI in your daily work as a lawyer. Okay, so you can see the results here. So personally, I also use sometimes AI in my daily work, but of course, we always need to verify data and of course, have in mind the data privacy aspects of what we put in applications. So here are some statistics about AI and its usage in law firms. And now I would like to talk briefly about AI Act in general. So this is first comprehensive European regulation, which will be regulating usage and creation of AI systems. It is created to increase transparency, set clear rules of accountability, and create a space for innovation of AI systems. So the main goals of AI is to protect user rights by creating a classification of risk and creating clear obligations of what should be done by AI system providers to make it more safe, to make it safer and more transparent. And who does the AI Act apply to? So in general, AI Act will be extraterritorial because it may apply to every company which will place AI system on EU market. So even Chinese and US companies may be a subject to AI Act obligations if they will be providing AI system on European market, or if the outcome resulting from their AI system will be used on the European market. So this is pretty wide scope of applicability, because even companies which are not under our jurisdiction will have to be compliant with it. AI Act will also regulate definition of artificial intelligence, which will be aligned to the recently updated OECD definition. So the aim, when definition was created, the aim was to establish a technology-neutral, uniform definition for AI that could be applied to future systems, which is also in line with general approach when when technology regulation are created, because we try to do it as universal, but also as applicable as possible to for future systems, which is not easy, because of course regulation has to be also, we need to be able to execute the regulation. So it must have like some level of precision. Compliance grace period will be between 6 and 24 months after it will be adopted, which means that companies qualifying as providers or users of AI will have maximum 24 months to adjust their process to obligations resulting from the new regulation, which is a great space for us lawyers to support the market in this area. Obligation in AI Act will be risk-based. So AI Act classifies systems or divides systems into 4 levels of risk. So it will be minimal risk, limited risk, high risk, and unacceptable risk. And I would like to briefly tell about 2 highest levels, unacceptable risk and high risk. So when it comes to unacceptable risk, these are AI systems which are considered as a threat for humans, and they will be prohibited. Their usage in EU will be prohibited with some specific exceptions only. So these are biometric identification and categorization of people, social scoring systems, cognitive behavioral manipulation of people or specific vulnerable groups, and real-time and remote biometric identification system in publicly accessible spaces. So these generally are forbidden. When it comes to high-risk AI, these are AI systems which can negatively impact safety or fundamental rights. And this system, providers and users of these systems will have specific obligations, and they will have to meet specific obligations if they want to introduce their system in EU. So, as an example, high-risk systems are systems that are used in products falling under EU product safety legislation, like toys, aviation, cars, medical devices, and also systems which will influence or will be used in law enforcement, employment, HR, migration, asylum, education, and management of operational of critical infrastructure. So the most important parts. Okay, moving to fines and wrapping up this overview of AI Act. AI Act, of course, propose fines for violations of AI Act. It ranged from 35 million euro or 7% of global turnover to 7.5 million or 1.5 of turnover. And it depends on scale of violation or type of violation. And now, question to you. Of course, it's a very basic question, and we all ask it to ourselves. Are you afraid that AI will replace lawyers? Okay, so I think we are generally optimistic about our future, but juniors are threatened a bit by AI. So I think, like, my personal view on AI, and it can replace human and a lawyer. Yes, in some parts, yes, but also I see great possibilities for development for lawyers in area of AI, because I can see two perspectives. From the user perspective, AI will, of course, facilitate our work, make it more efficient. We'll be using these fancy AI tools in our daily work and in our legal offices. Courts will be digitalized, which will also make it more pleasant and make court proceedings quicker. But from lawyers' perspective and our legal practice, I think that it's a great chance for technology lawyers to develop skills, to be assistants for trusted advisors for business in and making sure that companies which are producing or utilizing AI will be compliant and will be AI compliant. So there is a great space to advise on compliance. And also every product which will be based on AI system also will have to be AI Act compliance. So I can see a great opportunity for lawyers here to support this digital and AI transformation. So overall, I think I feel optimistic about our future as lawyers, but we'll see. Thank you. Oh, I wanted to ask you last question if AI should be regulated or unregulated, but if you still want to answer, okay, I agree. It should be regulated as a regulatory lawyer. So.
Thank you very much, Alexandra. truly enjoyed participating in free service, although in at least part of them I was in a minority. Do we have a chance to see the results from this survey?
It's 9 votes for regulated and 1 for
Okay.
unregulated.
I see. I see.
Yeah.
I struggle to have a proper look at. Thank you very much once again. If there are any questions from the audience, I encourage you to ask them right now. Yeah, I know. Francesca is also thinking about lunch, but I see one question. So, could I ask for a microphone? Okay, but we've got also audience online, so let them hear you as well. Is there a microphone? Yes. Good. Ola, could you join us? The question is there.
Good afternoon to everybody. I appreciated both the presentations as well as the previous ones. And I thank you all for being here and sharing your views. Especially, I have one question which is directed to both the speakers, because it somehow targets the AI Act. As far as I can see, and everyone can see, Europe has been, since the antiquity, the birth of ethos, the birth of the ethic preoccupation about how to proceed, how to behave, how to act. This reflects not only in, as my colleague from Italy said, in our way of acting between the experience and, of course, the ethical limits, also goes directly to the core of the activity of the judges, which we have here very dignified and representative. I wish to understand better to what extent will this AI Act be an ethic limitation that works, of course, for the good, because it's ethic, but also somehow will make us lag behind if we see the global picture where other countries don't have this kind of worries. Okay, I would like to put this question to both of you. Thank you.
Thank you very much. Francesco, would you like to answer?
I'll try. It's very complicated. It is very complicated. In this regard, I'm not very optimistic as I generally am, because I fear that the answer it is with a few collateral damages. I don't think there's a way to avoid any collateral damage in the US so far, and China, the little we know of, had which is, of course, is a major player. We cannot not talk about China. They have a completely different approach. They are just pedal to the metal and let's see what happens. Let's see what we can develop, which is at the origin of the black box problem. And the lack of explainability of a lot of these tools. So we are already left behind in that regard. As I mean Europe, we are behind in that regard. Don't think there's any doubt about it. So it's a challenge. It's a challenge to see how the AI Act and if to what extent the AI Act will allow Europe to become, let's say, a beacon, if you will. Even for those companies that want to operate in an ethical, using ethical in a very broad sense manner, but we have at the same time to avoid some of the dangers that we've learned with the GDPR, for instance, with experience that we matured with GDPR, because there is basically no way for an enterprise to be 100% GDPR compliant. Let's be clear. I mean, there is of course some area that is never covered. And so if an enterprise wants to be 100% GDPR compliant, it simply cannot work. But I hope we've learned from that experience. We'll see, because the AI Act is not done yet. So it's a challenge. That's why I wanted to address broader questions. Otherwise, we become bureaucrats. We're not IT experts. IT experts are having the time of their life right now. I mean, it's just there are so many opportunities to work for them, and we are sinking in doubt. Therefore, we have to embrace doubt, if you will. Thank you.
Thank you very much, Francesco. Ola, would you like to add something?
So I, of course, agree with Francesco. We are already a bit behind with AI development, but also it's a good starting point for Europe to create and to start regulate how AI will be used in our jurisdiction. I was wondering, and I'm wondering how execution of the EU AI Act will go, and how it will be executed in practice. Because in theory, I think it looks good. EU is a big market, so companies will have to adjust to our regulatory landscape if they want to operate here. But it's the theory, and since AI systems are globalized, it's very difficult to say how in few years it will be executed. I'm not sure if I'm optimistic or I'm curious. Yeah.
Thank you very much. If I can add just one thing, I believe that your question touched the very core issue when it comes to the global approaches to regulate, not regulate AI. And I am just curious whether the decision to be ethical, to have a strict regulation within the European Union was done on purpose, or it just happened. If it was done on purpose, it's okay. So I hope that there are decision makers who did this decision that, yeah, we are bounded by very strict regulation, but at least there are some benefits, and that's our goal. Otherwise, we will be bounded by very strict rules with having no benefits at the same time. But I also want to raise that one specific issue was raised during the trialogue on AI Act and during the whole discussion, scientific and business one, that whether we would like to ban European IT startups or major players on tech fields, to block them and not allow them to produce, for example, prohibited AI system. And we do not know the final version of AI Act, but as far as I suspect, there will be no such ban. So in that case, IT business in Europe can still produce AI systems that will be prohibited here, but they can sell or let use somewhere else in the world. So still we can develop as Europe, as European IT, with the same, or at least be a part of the same race. But at the end, from the perspective of the protection of European citizens, we decided we just don't want that.
Sandboxes, right? That's okay. I'm kidding. That.
Okay. Thank you very much. We are far away from the time we should start our lunch. So thank you very much. Once again, I invite all of you upstairs to the lunch. And I also like to invite the speakers here, but also the speakers from the previous panel here for a second, just to collect the gift. Thank you very much.